Just so you know, we'll be recording this session for those that missed it or want to remember what was said. I'm going to give you a little preamble on Greenbackers, and then we'll kick off properly. So, for those of you who are new to Greenbackers or are revisiting for the first time, uh, we have a very simple mission. We're trying to remove the inefficiencies and barriers to early stage climate tech investment using digital technology to connect ventures to investors seamlessly and globally. And we've been doing this now for the last couple of years. Greenbackers started out as professional introducers, and now we have a platform to do this. And really, what we're trying to do is enable seed stage through to Series B stage companies to get their first institutional capital. And in our observation, we see founders are wearing many hats. They don't necessarily know investors. The pitch deck might not be tuned right. They're just not efficient yet at raising capital. And it's tough for the investors too. Uh, they are getting significant deal flow and sometimes deal overload. The deals that they see are not investment ready. Data is presented in various different ways, again, highly inefficient. And really what we're trying to do is bridge the valley of death. During the pandemic, we developed what's now become our flagship platform. It's an online deal room that very effectively introduces ventures to investors. We now have 240 funds on the platform, looking at 32 deals currently, all manner of professional funders, some angel syndicates. I think only one angel who can invest over 750K in a particular deal. And the investor geographies are global, weighted towards the UK and Western Europe, but many in North America, in Asia Pacific and Australasia, and the rest of the world. And what we do to catalyze engagement, it's not just Match.com for ventures and funders. We do investor roundtables. We run pitch events. We just had a mega pitch event that Brown Rudnick sponsored last month at COP26. That was an amazing program, and this is the forward trajectory of our program. Investor feedback so far has been very positive. Some testimonials, and we're open for business. So if you are getting ready to raise a fundraise, we might be able to help you. Happy to speak to you. Get a hold of us at greenbackers.com. My email address is on as well. We'd be delighted to engage with you. So a little preamble to this IP strategy session. We started with the premise that as part of any fundraising strategy, every clean tech business should also have a well-considered IP strategy, i.e. a documented approach to developing, protecting, using intellectual property, addressing competitor IP within their business plan. So when Brown Rudnick, who are specialists in this area, who know clean tech well and who sponsored our super pitch last month, suggested that they could contribute their expertise to this topic, it was a complete no-brainer for us. So here we are. So if you're developing a plan, just starting, want to fine-tune your existing one, then this is certainly the place to be. With us today, we have two senior practitioners from Brown Rudnick, Stephen James and Tom Myers. I'll let them introduce themselves and Brown Rudnick shortly. And during this session, we'll hope to cover IP portfolio creation, commercialization and monetization issues, offensive and defensive strategies, and of course the finance piece. We will have time for Q&A at the end. If you could ask your questions in the chat box, that'll help us a lot. And once again, if I could ask you to all keep your mics on mute, we'd really appreciate it. So with that, over to you, Stephen and Tom. I'll come off of my screen share now and allow you to come in as you wish. I think I'll do that. Here we go.
Well, thank you, Robert. Want to thank you and Greenbackers for sponsoring the event, and it's great to be here. Good afternoon, everyone. My name is Tom Myers. I'm the founder and chair of the life sciences practice at Rudnick, and also the practice group leader for the intellectual property group at the firm. Do life sciences, intellectual property, life sciences deal work, kind of writ large, so includes a lot of clean tech, but other things as well, diagnostics and therapeutics and a bunch of stuff in between medical devices. So we kind of do everything in the realm of the life sciences. And so the talk today is focused on IP. This is a very brief overview of a course that I've given at MIT at the business school. It's a 6-week course, and I'm distilling it down into 15 or 20 minutes. So, forgive me for the brevity, but happy to answer any specific questions you have. But I want to make three main points that I hope will be takeaways here with respect to IP. We've been doing this a long time. We tell people, and I think it's really true, we're not that smart. We've just been around for a long time. I've been doing this for 30 years, and we've seen a lot of things go right. We've seen a lot of things go wrong, and so we're pretty good at playing through the movie and trying to figure out what can happen with respect to IP. So I'm going to make 3 points. The first 2, and let me just do a screen share here. I've got a presentation that I can put up. Here it is. Just put it in slideshow mode here. Okay, there we go. So hopefully you all can see that. The first 2 points are that, and we'll talk about this in a minute, patents are only good to keep people from doing things you don't want them to do. So very unlike publications, peer-reviewed publications and other literature where, the point is to show people how smart you are. Patents aren't about that at all. They're business tools whose sole purpose is to keep folks from doing things you don't want them to do. The second point I want to make about patents before I launch into this is that the vast majority of them have no economic value. So, we've calculated that something right around 95% of patents in the United States have no economic value. So, and this is pretty easy to understand if you just go read a bunch of patents. So you read the claims of the patents that are supposed to be the exclusionary right, and it's just hard to tell if they exclude anything of commercial importance. And so this is measured by whether the patents are sold, successfully litigated, licensed, part of the value proposition for a company in a transaction, an M&A transaction or others. And so I want to talk about the way in which we approach patents, the way to approach patents to create the maximum economic value. So how to be the other 5%, how to be the 5% of patents that have true economic value. And that's what this is all about. And it's a method that has worked for us for a lot of years that I hope to convey to you again briefly here in just the next 15 minutes or so, the time that I have left. So let's talk about basics. And Robert, you can see the screen, right? Yeah, good. Okay. So patents only provide the right to exclude others. They don't give you an affirmative right to do anything. So this is a little test that we do on the first day of the class where we put up this stone wheel and talk about the Stone Age, and Robert Hocken has invented this thing here, this wheel, this kind of stone wheel, and he thinks it's an easier way to move things around rather than carrying them on his back. And he goes to his Stone Age patent lawyer and he says, "Can I patent that thing, that wheel?" And the patent lawyer says, "Sure, nobody's done that before. That's really interesting." So Robert gets a patent on the stone wheel. And then comes along Stephen James, and Stephen says, "You know what, I can improve on that stone wheel. I can add a hub and some spokes and it's going to work better. I can make it smaller and lighter and it's more resilient." And so Stephen goes to his Stone Age patent lawyer and says, "Can I patent this spoke wheel?" And the Stone Age patent lawyer says, "Sure, that's different than Robert's wheel. It's novel versus Robert's wheel. So sure, you can patent it. So Robert gets a patent on the wheel and Stephen gets a patent on the spoked wheel. And so the question for the students is, who can make spoked wheels? And we won't have that test here with this group. And so inevitably, 3/4 of them get this wrong. And these are pretty smart kids. But the answer is nobody. Nobody can make spoked wheels. And the reason nobody can make spoked wheels is that if Robert tries to make a spoked wheel, Stephen's got a patent that prevents him from using spoked wheels. If Stephen tries to make a spoked wheel, even though he owns the patent, Robert's got a patent that excludes everybody from using wheels generally. So neither party can make spoke wheels. Nobody can make spoke wheels. So these guys are going to do some kind of a cross-license deal. But the point of emphasis here is that patents give you the right to prevent people from doing things you don't want them to do, not the affirmative right to do anything. So this wheel, spoke wheel example, good one in terms of emphasizing the point that just having a patent alone doesn't give you the right to do anything. Okay, so how do you get a patent, and what is a patent? So the patent is an exchange of a full divulgation of the invention, full disclosure of the invention, tell them everything you need to know, and in exchange for a 20-year exclusivity right given to you by the government. So it's a contract with the government, and the government could be the United States government, it could be the UK government, it could be the Swiss government, it doesn't really matter, they're all the same. This contract for exclusivity, and the rationale for it is that it promotes technology disclosure, which then promotes technology development. So if everybody's keeping technology secret, we're going to be less likely to develop improvements in technology. And so this idea that, well, we'll give you exclusivity for a limited period of time here, 20 years, in exchange for a full disclosure, that's the best way to promote technology and development. And so the countries of the world have signed on to that premise, and that's resulted in these patents that provide the exclusionary right. Okay, so and real quickly, the three things that you need for a patent: your patent claims, and the claims are what define the exclusionary right. So the claims are like the deed to your real property. Okay, and what you need in order to get those claims that provide that exclusionary right is you have to claim something that's novel, and that just means that nobody has ever done the exact same thing as you before. You have to claim something that's not obvious, which is a little bit of an amorphous concept that nobody really understands, including the courts. But you have to claim something that's not so similar to something that others have developed that it would be kind of an obvious improvement. And then you have to provide that enablement that I talked about before. You have to teach one of ordinary skill in the art how to make and use your invention fully. And for that, you get the exclusionary 20-year right. All right. So that's all fine. And that's what patents are. And everybody knows that. And so, people go out and get patents all the time. So here's the third point, and the most important one of this talk. Okay. Patents are not primarily about technology. That's the counterintuitive notion about patents. And that's where people go wrong with patents. That's why patents have no economic value. It's because people mistake patents as technology documents. They're not primarily about technology. They're primarily about creating exclusive rights in an area of commercial importance, what we call barriers to entry. And so I'll give you, one very quick and easy to understand example of this, which I use as the example because, you don't have to have a technology background to understand it. And this is, a 25-year-old story now, but we've done this many times since. A couple of folks who started a company came in to talk to me about some mutations that they found that were early indicators of colorectal cancer, polyps that might develop into colorectal cancer. And the standard of care for screening diagnostics for colorectal cancer is a colonoscopy. And, we all know what that is. Compliance is low because nobody likes it. 6-foot pipe, where it goes. So it's just, compliant. Wouldn't it be great if we had a non-invasive way to determine whether you were at risk of developing polyps that would potentially form colorectal cancer? So, we've got this panel of mutations that we found that indicate that risk. So, Tom, go patent that panel of mutations. And we thought about it and said, well, we could do that, but what if somebody else comes up with a more informative panel of mutations, a better one? What if they have more money than you? they're going to outcompete you. So let's think about what the barrier to entry might be, and let's patent that. And it turns out it was really hard, especially at the time, to get human DNA out of stool, out of poop. And so the barrier to entry became the poop, and we got 7 issued patents on homogenizing poop, freezing it and scraping it, and it was all very humorous. But the barrier to entry there was the sample. So now it doesn't matter if you have a more informative panel of mutations. You're not going to be able to compete because you can't access the sample in order to assay for those mutations, because somebody else has a barrier to entry around the sample. Good luck doing it in blood or sputum or saliva or anywhere else. And so that technology became it is the foundational technology for a test called the Cologuard test, which is offered by Exact Sciences, and which is the only non-invasive screening diagnostic for average risk populations for polyps that are indicative of potential for colorectal. And so that's an idea of when we think about barriers to entry, what we're talking about is looking at the commercial objectives that someone would need to meet in order to compete with us. And that's what we want to patent. So it's really this intersection between the innovation that you have as a company and the commercial objectives of the company. Where are those barriers to entry? That intersection is where you patent. That zone of strategic patentability that matches the available IP, the innovation, with the business opportunities. And so there are these broad categories of strategic IP, like the poop example I gave you. That's a pretty broad barrier to entry. You can't use the sample, you can't compete. Doesn't matter if you have better technology or not. And then there are incremental barriers that together might form a broad barrier to entry. So there are little improvements that if you stack them on top of one another, you might have a broad barrier. And then there's the 95% of patents that are simply what we call technology improvements, or this sort of very specific incremental kinds of things where you claim put on your white lab coat, walk into the lab, start squirting stuff around. Okay, easy to get around. They don't really provide barriers to entry, and they're really not worth the money that you're spending on them, because you're spending a lot of money to get patents. It's just not worth it if you're not doing it for a purpose, and that purpose should be to create a barrier to entry, to keep people from doing things that you don't want them to do. And spending the time to figure out what those barriers are and how to marry up your innovation with the barriers is worth it. That's how you're going to create value through patents. So the take-home message here is that patents should be driven by business opportunities, not by incremental technology improvements. So when you're thinking about patents, you're thinking about hiring somebody, or you think doing it yourself, translating innovation into commercial barriers to entry. So taking a step back and figuring out, okay, what innovation do we have? How can we express that innovation in the form of a patent claim or claims that will provide that barrier to entry? So I've got about 2 minutes left, and I want to I just want to make a couple of additional points, because like I said, this is really, this is a 6-week I'm trying to do in 20 minutes. But one of the things that we've found about this approach, and we've done it, over and over again, I gave you that simple, but we've done it in other contexts where we found that having one barrier to entry is usually not enough. Usually you want multiple barriers to entry, you want multiple patent claims that cover multiple ways of getting in and competing. And that part of an overall patent strategy is to figure out where those barriers to entry are, how to address them with patent claims, and then to have multiples of them so that you're not reliant on one patent. And the other advantage of doing that is that having multiple patents is actually a litigation deterrent. All right, none of us, including me, and I was out at a company, did a company for a while between law firm gigs, and so I get this because I was on the other side of this equation for a while. Nobody wants to pay lawyers to go to court and fight about things, and one way to deter that is to have a strong patent portfolio, so that if somebody comes to you with a patent and says, hey, we think you're infringing our patent, it's nice to be able to say, yeah, well, we don't think we are, but you know what, you're infringing 10 of ours, and here they are. It's like, dating myself here, but the old Crocodile Dundee movie where they're outside of the opera house, and this kid comes up with a knife, and she says, be careful, he has a knife, and Crocodile says, no, this is a knife, and he pulls out that big machete. We want to be the guys with the big machete. And that's in the form of, multiple patents that, make it unattractive for somebody else, even if they're big and well-funded, to sue us and to create litigation havoc. So that's the other reason that you want to do it. But you can only effectively do that if your patents have created those barriers to entry in the first place. So it increases enterprise value, it deters litigation, and then it's a value in and of itself. And we've had companies, unfortunately, that haven't succeeded, but we've sold off the IP, and that value of that IP is paid back the investors. Not a great day for the investors, but a hell of a lot better than losing your money. So that's the other feature of this. You've created some value that somebody else might use down the line. And again, with apologies for rushing through this, I want to give Stephen a chance to jump in here and talk about trademarks and copyrights, but would be very happy to answer questions at the end or have a further discussion with any of you. So with that, I'll turn it over to Stephen James.
Great, thank you very much, Tom. I'm a partner in the London office of Brown Rudnick, and I head up our UK and European intellectual property team and assist with litigation, disputes work, transactional work, but also just generally counselling on strategy. So I am going to attempt to share my screen, so bear with me. Okay.
And as you do that, Stephen, just to the general audience, if you have any questions, and we've already had a couple of questions that I'll do my best to curate towards the end. Please put them in the chat box, please, and we'll get to Q&A in just a little bit.
Right. Can you see my screen?
See it just great.
Perfect. Okay, so just building on what some of the things that Tom has been saying, IP's increasingly being viewed as a business asset and almost an asset class in itself. An interesting statistic is that 70% of a typical company's value lies in its intangible assets. And I think IP needs to be seen as not just having a registration and a piece of paper that you put in the background, but also using it as a key part of your strategy going forward to try and create those barriers to entry, to have the armory that you need, as Tom was talking to. And there are various different types of IP. Patents is going to be absolutely crucial for the clean tech space, and Tom's already talked through that. And then there are going to be other aspects as well. So the flip side of patents is confidential information, trade secrets, where you're not disclosing that information. You need to be very careful about how you manage that. But there are going to be other aspects in relation to how you manage your brand, design rights, copyright, and so on. And so you need to be looking at IP holistically and using that to drive revenue in itself. So if we focus on trademarks. Trademarks are key because they're associated with reputation and public perception. And there has been a recent green rush to protect certain brand names that include terms like green, eco, earth, enviro, and so on. And the EU Intellectual Property Office recently reported a huge increase in the number of trademark applications that relate to environmental protection, sustainability, and so on. I think 11% of all trademarks registered last year related to sustainability and environmental related matters. And trademarks function like a badge of origin. They are something that you can use to build brand equity and value in a business. It can drive revenue too. So it's very important that you have a strategy in place. And with things like clean tech companies as well, certification marks or collective marks can be a valuable strategy, whereby instead of applying for and using a service mark yourself, what you're doing is creating certain standards whereby you file an application, and other people, if they meet those standards, can then use that certification mark. So it's something that you wouldn't be using, but a third party would. And you increasingly find that where you're in an environment where you're creating standards that you want people to meet. So when you're thinking about trademarks, it's not just marks that you would use, it's certification marks as well. So when we're talking about building up a trademark portfolio, so how you protect your brand and build brand equity up, you should be carrying out some due diligence checks and clearance checks, and you should be instructing someone like me to do that, to make sure that the pathway is clear, that you're not trampling on anyone's territory, because the worst thing you want to do, or the last thing you want to do, is to launch a brand and then you get a cease and desist letter and you spend all this money on creating fabulous collateral and promoting your brand, and you have to change it all. So making sure that you do those searches and formulating a trademark prosecution strategy from the off is sensible. Registering trademarks is pretty cheap and inexpensive compared to certainly filing and protecting patents. And when you look at it, you should be looking at filing early and focusing on your core territories as well. Some people say, well, I'll wait, I'll save, I'll start using the mark and I'll register it when I've got a bit more funding later on down the line. But if you do that, you're potentially risking someone else jumping in before you, leaving you to argue common law rights, such as passing off, for example, in the UK, which are more challenging to prove because you're relying on evidence of actually using the mark, and that evidence being sufficient to give rise to things like goodwill and so on. So if you can get a mark filed, even if it's a basic word mark covering your core goods and services, that could save you a heck of a lot of pain earlier on. It's also important to bear in mind that different registries have different approaches to how they look at goods and services that you're applying for. They deal with objections to trademark applications and third-party oppositions in all sorts of different ways. I gave an hour-long talk on this the other week, so it's a whole subject in itself. But again, it's the idea of thinking, okay, well, which territories do I want to be in? How can I do that in the most cost-effective way possible? Some people use something called the Madrid Protocol, which is an international form of registering trademarks, allowing you to file through a single application and then prosecute applications in different territories. It's the sort of trademark equivalent to patents and the Patent Cooperation Treaty. It has some advantages because it's less expensive than filing in individual territories, but there are issues. If the mark that you're basing your filing on gets attacked and is invalidated, it can mean that a whole series of marks that you're basing your application on in different territories could also be challenged. And also, you don't have much freedom to change your trademark specification when you file it. So it's important to get the advice early and think about how you're going to file and maintain a trademark portfolio in the most cost-effective way. And once you've got those registrations in, it's important to make sure you're monitoring how other people are using your marks and taking action when you need to. So I'm going to go through this relatively quickly, just in the interest of time. But essentially, when you're picking a mark, it's important to pick something that is distinctive, that doesn't simply describe the goods or services that you're actually providing, because you're going to get rejections. It shouldn't be terms that are customary in the language, such as aspirin. And you need to make sure that when you actually protecting your mark, you're doing it in a way that's consistent, which will help you get the registrations through. Shape marks you're always going to struggle to register, because trademarks are about a badge of origin. They're not about normally just simply the shape of a product itself. So when you're thinking about names, look at what's on the register, try and pick something that isn't descriptive of what your goods and services are. The example I always give is Kodak, which is a solid example of a trademark registration, because it's got absolutely nothing to do with the goods and services that are provided under that name. When you go through that process, you need to think for trademark registrations, you need to think about, well, what other rights are on the register? Because if there are people who already have identical or similar marks, or they have similar marks registered for identical or similar goods and services, and there's a risk of confusion, that means potentially your mark can be blocked. Those who have a mark with a reputation, so famous marks typically, such as Coca-Cola, etc., they have additional rights, which means that if you're likely to be right, if your use of a mark could be considered to be riding on their coattails, tarnishing their brand, or diluting it in any way, they have extra rights to challenge your application. So making sure you're thinking about the sorts of marks we're doing those clearance searches will save you a heck of a lot of pain. So moving on to copyright. Copyright is all about the the expression of ideas rather than ideas themselves. Ideas are protected by patents, the functionality. Copyright is all about expression, and it needs a degree of creativity. It's a relatively low bar, but you need to show some skill, judgment, and a modicum of creativity in order to get copyright protected. But the advantage of it is that it rises automatically. You don't need to register it, save some limited examples in the US if you're taking infringement action. But you do need to prove copying. So if you compare it to patents, where if you fall within the claims that Tom was talking about earlier, you're infringing. With copyright, you need to prove copying of that work in order to be able to take action over it. But sort of some tips with copyright is to make sure that when you're creating new documents, whether it be written materials, drawings, whether you're developing source code for your business, that you keep an audit trail of what you're doing and making sure that you're dating it. So when you're trying to prove your right to your copyright in the work, you have that audit trail ready. A couple of common pitfalls that you get with copyright and intellectual property generally is that whilst IP in most jurisdictions that's created by an employee will belong to the employer if it's created during the course of their employment, we often have issues where independent contractors who create IP, the companies in question haven't transferred those rights back to the company, because under English law and a number of different jurisdictions, if you're hiring an independent contractor and they, for example, design your website or they've been involved in your product development, they will be the first owner of that IP unless you have it assigned and transferred under a written agreement. So there are lots of famous examples of companies who've gone out, hired a contractor to help them with develop the IP, haven't assigned it across, assuming that they own it because they paid for it, and actually they don't. So it's important to make sure that you take those steps early to ensure that your business owns those relevant rights, and also ensure that your rights are registered as soon as possible. In the interest of time, I'm going to skip over design rights, but they're another interesting right that you can potentially rely on and could be very applicable in this space. So design rights are called registered designs, or the registered form of it is called registered designs in the UK and Europe. In the US, they're known as design patents, and they can be useful in giving you a good degree of protection. In the UK and EU, you can have up to 25 years worth of protection if you register a design. There are also certain unregistered design rights that apply in the UK and Europe as well. So even if you're not registering your designs, you can secure some protection for them. Although in that example, you have to show copying when you're talking about unregistered rights. With a registered right, if your design has the same overall impression or gives the same overall impression as another design, a registered design, you could be liable for infringement. So to illustrate this, I just wanted to show you Tesla's semi-truck design pattern, just to show how registered designs are filed and configured. And you can see here that the two designs that are subject of a design pattern registration in the US. And where you have the hard lines and they're all joined together, so figure 1, you can see that is a claim to protect that element of the design. And line drawings are good to use because they can give you broader protection. But in the second example, the one marked figure 8, you see lots of dotted lines appear. And that's effectively saying, I am not claiming this aspect of this design. What I'm claiming protection for is actually that panel that you can see with the solid line at the back of the design of the cabin. And that's what you're claiming protection over. So when you're thinking about building up your portfolio, what you want, if you're looking at the visual aspects of a design that you created, is to get a portfolio of different design rights that you build up over time, and you're protecting not just the overall design of, say, a cabin, as in this example, of the front part of the truck, but also specific aspects that you think are novel and have individual character. So when you're talking about commercializing and monetizing IP rights, there are copyright, trademarks, patents, etc., are all proprietary rights, so it can be transferred and assigned. And when you're assigning trademarks, you need to make sure that you're assigning the goodwill that sits with that. The assignment of IP is separate to the idea of simply selling an item. So you could sell a painting, for example, but that doesn't assign the copyright, the underlying copyright in that painting to the buyer itself. You need to have a separate assignment of IP. With R&D agreements, which are going to be important in this space as well, it's that you need to be careful around joint IP ownership, because in those circumstances you could potentially have 2 or 3 parties who all have a claim to own the IP, but there can be deadlock unless there's agreement. So when you're looking at R&D and collaboration agreements, carefully setting out who can do what in relation to that IP is a very important thing. I'll talk very briefly about assignment and licensing, but assignment is the transfer of the ownership of IP. So when I was talking about contractors earlier, that's when you need to assign the rights over. You want to transfer the rights to your company. And you can, with assignments and licenses are about having a permission to use the IP rather than actually owning the IP itself. But the important thing with this is that you can split assignments and licenses up in all sorts of different ways. And they can give all different ways of exploiting and monetizing the rights that you have. So for example, with licenses, you can grant exclusive licenses or non-exclusive licenses or even sole licenses in all sorts of different territories, allowing you to split up and monetize the IP that you create in all sorts of different ways. So just to finish up, when we're talking about how you develop an IP strategy, and this has been a super whistle-stop tour through the various different rights, is a starting point could be to look at what are your competitors doing in terms of their rights. That always will give you an indication of perhaps how you should approach things. It's not necessarily a definitive thing, and they may not have it right, but it could at least give you an indication of where they're investing. Are they investing in patents? Are they investing in designs? Are they investing in trademarks? And with each of these things, you should be conducting a cost-benefit analysis clearly. And the advantage of things like registered designs, design patents, etc., is that they can be registered far more quickly than a utility patent can, patents that Tom was talking about. So that may be the case. So just so you can secure some protection, you might file some designs early and quickly to protect the appearance of what you're doing, as well as the functionality, which is the utility patent component. And you should also use aspects of the registration process to your advantage. So for example, grace periods, when you release your design, for example, to the public, you have up to a year in order to register that design. You have a year's window in order to do that. Priority periods. So with trademarks, for example, you can file a trademark in the UK and then have up to 6 months to file in other countries and claim back to that UK filing date, so no one jumps ahead of you, and using extensions and things where you can. But I think the important thing is to make sure that when you're going through the IP process, that you're documenting what you have, you start building up a portfolio and thinking about, well, how can I exploit this IP? It's not just a case of as soon as you've got the certificate, you're just going to put it away. It's also about making sure that you're thinking about, well, how can I exploit these rights, and building out that armory of IP so you can then use it as for defensive strategies, offensive strategies when you need to use it as well. But also carving out your own niche in the marketplace so you can grow as a business as well. So that was it from me, and happy to take questions.
Really, really good. Thank you very much, Stephen and Thomas. And thanks for flashing up. We'll leave those up for a bit. Your email addresses, many aspects and angles to consider, and a very strong argument for pulling in expertise. Stephen, Tom, we've got some good questions here. I'm going to try to get to as many as possible. Stephen, you first. While we're on trademark, are you seeing a preference? Halim Chowdhury asked this. Are you seeing a preference as to which jurisdiction firms are interested in placing them? I think that's not so much a what, but as a where should firms, and I imagine as you're in the UK, you might want to start from the UK and spread outward. But when compiling the budget for protection, where do you start?
Well, I think the focus has got to be where you're using the mark, where your customers are based, where you're targeting. So the most popular jurisdictions that clients speak to me about are the UK, EU, and US. And a lot of work that we do is transatlantic, I should say, in nature. And so they're the priorities. But after that, it's going to be where you're actively trading, where you're looking to expand into. But I think what I'd say in relation to that is, it's important when you're looking at the clearance searches, if you think that there's a real likelihood that you're going to go into a territory relatively soon, is to make sure that you're conducting those clearance searches early in those territories, because what you don't want to happen is that you file in, you wait, don't take advantage of priority periods, and someone jumps ahead of you in, say, Australia, for example. So seeing where the marks are free up front and knowing what the landscape looks like is very, very important, and then focusing on those core territories. And as I said during my presentation, you can always defer for up to 6 months if you wanted to before filing in other territories. But I say that they are the most common ones that I see.
Okay, thanks for that. Amber Khan has got a very good question as far as defensibility is concerned. And how do you protect against a large, well-funded competitor that takes a view that a small startup may not be able to adequately defend its patent? You know, looking at the cost of typical patent defenses and the number of times a granted patent is subsequently seen to have been improperly granted, et cetera. And also, I've got a follow on to that myself, about defensibility and any guidance on how you carve out budget, for the unfortunate possibility that you might have to defend your patent or trademark.
Well, so there's really two forms of that question. One is where somebody, a third party, attacks you with their patent, and the other is where somebody challenges your patents. Dealing with the first one, a couple things. So they do say that patent litigation is the sport of kings. It's not cheap. So that just is a fact. Now, there are different ways around that. I mentioned one during the talk where if you have an arsenal of patents that you can assert back, that raises the stakes, even with a large company. And then having, so I mentioned that, but then the other things would be having an FTO strategy where, you know what patents are out there, engaging someone to look at this idea of freedom to operate, knowing what patents and patent applications are out there, knowing where the vulnerabilities are. Just one quick example, I had a client who was threatened with a patent, and had a royalty demand and an upfront fee demand, and we found some invalidity art that rendered that patent, we think, invalid. Rather than fight it, they gave up and they ended up paying us. So having control over that prior art, knowing what's out there, sort of as we say here, knowing where the bodies are buried, is an important strategic implement to have in your arsenal. And then, finally, there are other folks who may take that burden, the economic burden, off of your shoulders if you do get sued. There are litigation funders that I think in the UK as well as in America, we see that happening more frequently these days. And then strategic partners who are a threat to take those patents on and assert them or invalidate them. We've had that happen as well, although less frequently. So there's really no good answer to that question, but I think that the only wrong strategy is to have no patents, to have no FTO strategy, not to have thought about it. I think if you have an arsenal of patents that you can assert, and patents that have value. So there's a whole other hour that we could spend talking about what we mean by that. What do we mean by value, and how do you actually go about creating these valuable patents versus the many, many invaluable patents, and how to tell the difference? In this short time frame, I'll give you just one thing to think about. That is, if you want to know the value of a patent without knowing anything else, just weigh it. The longer it is, the more pages it is, the less valuable it is. I think there's a high degree of correlation there. And then look at the claims. The more words, the less valuable. You want crisp claims that define a barrier to entry very clearly so that everybody can see it. Because remember, the people who are evaluating your patents typically are not technology folks. The people who are looking at your patents are business people, they're lawyers, they're judges, maybe they're jurors, but they're people who don't have the same technical background that you have. And so writing these documents for that audience is super important. And that goes back again to this point that patents aren't about technology. They're about creating business barriers. They're business documents, and they should be written like business documents. And there's an art to doing that. But if you do it well, you get a better result in terms of the claims that are granted, and a better result in terms of the evaluation of those patents later on when somebody, whether it's an investor or a judge or an acquirer or a partner, is reviewing those patents.
I'm aware of insurability products, such as IP insurance, to help businesses defend itself against claims of IP infringement. Do you have a view on that? Is this a good thing, or is it a waste of money?
I have a view on it. It's just my view. I don't think it's a good way to spend money. Personally, that's just my view. I respect the fact that others would disagree with that. Certainly, we don't see that a lot. And I think doing these sort of fundamental things to establish your barriers to entry, to get the bulk, to know the landscape, are going to be much more valuable in the long run.
Yeah,
okay.
I think I probably agree with that as well. You do see it, and some companies are keen to look at it and make inquiries and will take out that insurance. But I think the far more important thing, as Tom was alluding to, is to know what the landscape looks like. Don't do it blind. Don't file an application blind, whether it's trademarks, patents, designs, etc., because it could become extremely painful later on. That's far more valuable, I think, having that strategy, knowing where the issues are, and either designing around that, steering clear, rethinking things, and doing that before you're on the other end of a lawsuit is far more valuable than, I think, just looking at insurance.
Okay, thank you for that. I'm conscious that we're running over a bit, but I'm happy to do that to the top of the hour if Stephen, if you and Tom are good to go. We still have questions. I'm going to do these in no particular order. Here's one from Sandra Sassow of Siab Energy. If you're rebranding, should you continue to renew the registrations for trademarks or previous trademarks? I think is the question.
It depends what the reason is for rebranding. If you're being forced to rebrand, often you're required to cease or surrender those marks. If you're doing it through choice, then I would say, well, the only value really of keeping those going is if you're planning to do something with them. For example, sell them, those trademarks, because otherwise after 5 years, certainly in the UK and Europe, they could be vulnerable to challenge and attack. So it's only really worth doing if you're planning to actually do anything with them. But most of the time, what will happen is trademarks, say in the UK and Europe, will be valid for 10 years from registration. Most people just won't renew them as and when they come up for renewal if they're no longer using them. So that's typically what you'd see.
Okay. Here's a licensing question. Is there the question is, what is the typical royalty rate? I'm going to rephrase that. Is there a typical royalty rate for the licensing of IP? And I think what Steve Lua of Unitrove is trying to get to is do royalties cover the cost of patents?
Yeah, they can. There's no simple answer to that question. I do a lot of licensing because that's the back end of this, right? It's creating a patent strategy, it's implementing it by getting the patents, and then it's monetizing them on the back end. You got to do that. And so we do a lot of licensing. It really is sector dependent and technology dependent. Royalty ranges can be anywhere from 0.5% to the high teens, depending on the sector. So you really got to look at that. You got to look at who the licensee and licensor are. There's a lot of specifics, so there's no one answer to that. But if someone gives us parameters, we certainly have a huge database of priors that we can look at and kind of get to a range that we think is reasonable under the circumstances.
Well, thanks for that. And here's I love questions like this. Here's a Brexit question. What was the effect? Was there an effect of the UK leaving the EU on patent validity in the UK and in the EU?
Not in relation to patents, because it's the patent system is governed by the EPO, which is separate to the EU system. So so in other words, when you apply for a patent in Europe, you'll get a bundle of different patents, and it's not a single EU registration that you have. But Brexit had an effect in all sorts of different ways on European trademarks and them covering the UK, and same with EU designs as well. And there have been some transitional procedures which are now over, and effectively there's a separation between the two. So when you're looking at strategy now, you should be looking at both the UK and the EU as separate entities that you want to secure protection in. But that's really when we're talking about trademarks and designs rather than patents, which is a separate process and wasn't affected by Brexit.
Thank you for that. I'm going to ask a question. Steve Lewis has posted it for the second time. I didn't get to it the first time, and this is an interesting one, and it's based on clean tech as an asset class, and how good is green, and should it be a consideration? So Elon Musk states that in quote unquote, in the spirit of open source movement, Tesla would not initiate patent lawsuits against anyone who in good faith wants to use their technology. I'm taking that on faith, Stephen, that is an actual quote from Elon Musk. The question is it an ethical dilemma or even a contradiction to take out patents to create barriers to entry for other clean energy contenders if the ambition is to accelerate global clean energy uptake? So in other words, if this is all good stuff that we're doing, should we be creating barriers to entry for other contenders? It's an interesting question. I'd love to get your feedback on that.
Yeah, it's a really interesting question in clean tech, and it's come up in the area of COVID response as well.
Yeah.
The vaccines and antivirals. So, I'm not going to get into the politics on that. I think if you buy into the premise, why do we have a patent system? I think that's the first order question. Do we want a patent system or not? And the value of a patent system is that, if you don't have one, people are going to keep everything secret. So it's better to have a system that promotes the full divulgation of technology to enable others to improve upon it. That was a decision that was made. And a long time ago in a number of different countries. And in my country, in the United States, it's the only business right that's specifically codified in our Constitution. And there are similar provisions in other countries. And so it was decided that was the best way to promote technology development. And you've got to do something in exchange for that full divulgation. And the answer was, well, we'll give you an exclusive right for some limited period of time. And so if you have to buy into that premise, I mean, if you're an open source person and you think everything should just be freely available, that's another philosophy. And, if we did that obviously would result in a different regime. And my personal opinion is that it would result in less technology being available and disclosed for improvement. So, I believe in the patent system. I think it's there for a reason. I think, we need to give innovators, a return on their investment in the form of this exclusivity. There may be exceptions to that, and I'm not going to get into an argument whether clean tech generally should be an exception to that, but that's it's an argument that people have all the time, and there are folks like Mr. Musk and others who just think everything should be open source. But my personal opinion is that I think that there's a lot of unintended consequences that would have a negative impact on technology if that were the case.
I think we could continue on for another half hour at the very least, but I'm afraid I'm going to have to call it to a close. I appreciate that there are some questions that haven't been answered. I have peeled off all of them, but I would suggest that if you have any specific questions, bring it to Thomas and Stephen, who I'm sure would be delighted to take your emails or phone calls. We will be sharing this presentation. We're going to do a little bit of post-production work on this session, and with Thomas and Stephen's permission, share elements of their presentation in a taped format. I think this has been an outstanding session, one of the best IP how-tos that I've seen, and really appreciate Tom, Steve, your contribution today. Thank you very, very much for all of your attention. I'm impressed with how many of you have stayed late to see the Q&A to the end. We'll get something out to all of you who attended. Anyone who didn't, this session has been recorded. We'll do a little bit of post-production work afterwards and get it out to you as quickly as we can. On behalf of the Greenbackers team, thank you very much. Tom, Steve, once again, thank you so much for your contribution. It's been a really outstanding session, and any support that any of the rest of you folk need on your fundraising and funding journeys, do feel free to get in touch with us. We're very easy to speak to. With that, I'll love you and leave you. Thanks again for your time, and we'll speak to you again soon.